Wouldn't it be great if there was a court case that forced banks to stop foreclosure activity? And let's not even just say a regular court case, but instead let's say there's an appellate court case that forced banks to stop foreclosure activity. Well, it would be great, and it is great, because very recently there was a court case that came out of the Ninth Circuit. And once again, this wasn't just a regular court case, it was an appellate panel case of the bankruptcy court. And what this case said was that Wells Fargo did not have the proper documents to show they were the proper party in interest in order to force a foreclosure of property, and therefore Wells Fargo had to stop its foreclosure activity. And this kind of goes to the adage of just show me the note. There's a lot of people saying out there that the banks have to show the note. The banks have won a lot of decisions saying no, they don't have to. But here we have a bankruptcy appellate panel, a federal court, saying, yeah, the banks have to play by the same rules as everybody else. Now, what was the actual court case? Well, I'm glad you asked. Let's go through that. Here's the court case. Way back when in 2006, the debtors, the people who filed the bankruptcy, there's no controversy. They executed a promissory note in favor of the company who loaned them the money. They also executed a mortgage. They signed a mortgage to the people who agreed to lend them the money. And basically that mortgage said if they didn't make payments on their promissory note on their mortgage, in that case, the mortgage company, GSF, who they originally borrowed the money from, could foreclose upon them. Okay, let's fast forward 3 years. In June of '09, the couple, they went ahead and they filed a Chapter 13 bankruptcy. And on their bankruptcy, they listed the mortgage servicing company, AHMSI, as a secured creditor. So they actually listed the new party who claims that they were the servicing company of their debt. They listed them on their bankruptcy schedules to give them notice. Okay, life is good. Everyone's doing everything right properly so far. Now, here's the interesting thing. The servicing company, during the bankruptcy, the servicing company filed a proof of claim saying that the debtors owed the servicing company money. And not only did they file a proof of claim, they also provided a copy of the promissory note. They also provided a copy of the mortgage and also a recorded assignment of mortgage. So the servicing company provided a lot of the documents that a lot of people on the show me the note side say most of these companies can't provide. Well, in this case, the servicing company, who is acting on behalf of Wells Fargo, provided all these documents. So in providing these documents, the servicing company wanted to say that they had a valid claim where the people who were filing bankruptcy owed the servicing company money on behalf of Wells Fargo. Now, not only did the servicing company file a claim against the debtors, the people who filed bankruptcy, but Wells Fargo also went to the bankruptcy court and said, bankruptcy court, what we would like to do is we would like to start foreclosure proceedings on the property. Will you please allow us to start up foreclosure proceedings on the property? Well, the bankruptcy court, they allowed the servicing company's claim to go through, and they also allowed Wells Fargo to start foreclosure activities. But fortunately for the debtors here, they had some good attorneys, and these attorneys were brave attorneys, and they said, bankruptcy court, we don't agree with your opinion, so let's appeal this decision. Let's go to a higher court. So they did go to the higher court, and the higher court looked at the servicing company's request for payment, and they also looked at Wells Fargo's request to start foreclosure activity. And what the appellate court did basically remind me of the old Wendy's commercials. Those of you who are over 35 years old probably remember these. So the appellate court said, where's the beef? And the way they said that is they said, who is the proper party in interest in this case? Who actually has the right? Who has the standing to force this promissory note to be paid and to commit a foreclosure action, to start prosecuting a foreclosure action? So the court ran through all their wonderful analysis, which I'm going to spare you the 46 pages that they went through the analysis. But here's the bottom line. The court, and you're going to have to forgive me, I'm going to read almost verbatim this paragraph because it's just so incredibly powerful. It said, applying these holdings in the relief from stay appeal, we determined that the record does not support the bankruptcy's finding that Wells Fargo had standing. We thus reversed the bankruptcy court's relief from stay order. Translation? Wells Fargo could not start foreclosure activity on the people who filed bankruptcy. Wells Fargo could not foreclose on the property. They had to cease their foreclosure activities. Then they go on to say, in AHMSI's claim objection appeal, the bankruptcy court did not make findings necessary to determine their standing, so we must vacate the claim objection order and remand for further proceedings. Translation: the loan servicing company couldn't prove they were the proper party, that they were the party in interest, and so therefore they didn't have a valid claim unless the bankruptcy court made a determination later on down the road that they did have the proper paperwork. Now, what's the net effect of this ruling? The net effect of this ruling is this. All those people who've been shouting, show me the note, show me the note, show me the note. This court decision basically backs up those shoutings. If the new mortgage company cannot prove that they are the valid holder of that note, then they can't initiate foreclosure activity. They can't file a claim in bankruptcy where the debtor has to pay them off. So what is the significance of this ruling? The significance of this ruling is this. Over the years, a lot of these mortgage companies have just been swapping this paper back and forth, and they've been very sloppy with their paperwork. If they've been sloppy with their paperwork and they no longer have the proper paperwork to show the courts that they are the proper party in interest in order to enforce the rights on the promissory note, to enforce the rights on the mortgage, in this bankruptcy ruling, the bankruptcy court says, if you can't show us the proper paperwork, we're not going to allow your claims to go through. So stop and think about this. Basically, an appellate bankruptcy court is saying, banks, you're going to have to stop foreclosure activity unless you can produce the proper paperwork, and they probably can't produce that proper paperwork. Not only are they saying that, but they're also saying, banks, unless you have the proper paperwork, the debtor is not going to have to make payments to you in bankruptcy either. And the ruling we make about whether you have a valid debt or not, it's going to even survive out of bankruptcy court. It's going to apply to civil court. So even whenever the debtors get out of bankruptcy, in civil court, the bank can't come back and say they owe us money on this promissory note. So this ruling is absolutely astounding. Now, does this ruling apply to your particular situation? Don't know. It all depends. Number one big fact pattern is, was your note assigned? If you're still making payments to the mortgage company who you borrowed the money from, this case probably doesn't apply to you. This case only applies to those mortgage companies that had sloppy paperwork. So number one is, was your note assigned? If your note was assigned, that's a good factor in your analysis to determine if this applies to you. Number two, this is a bankruptcy court ruling. And by the way, this is important as a bankruptcy court ruling. This is probably favorable as a bankruptcy court ruling because a lot of state courts, non-federal courts that is to say, they've been letting the banks get away with this stuff. They've been letting the banks ride roughshod over the consumers. Now we've got the federal court system standing up for the consumers. And by the way, bankruptcy courts are kind of rocket dockets. They move a lot faster than the state courts, so you can get this determination done a lot faster as well. So for this to work, you're probably going to have to file bankruptcy, which some of you, that's going to be a letdown, but let's face it, your credit's probably already shot anyway. So now we've got to determine whether you even qualify for bankruptcy or not. So the two main determinants to see if this is going to work for you is, number one, has your note been assigned? And number two, do you qualify for bankruptcy? If you do meet those two standards, there's a good chance we can force your bank to stop foreclosure activity. And there's a slight chance your note, your promissory note, may disappear as well. To find out if these things actually apply to you, by all means, give us a phone call, 760-345-1500. Once again, that's 760-345-1500, or visit us at gartlandlaw.com, GARTLAND law.com. Thank you very much for your time.